Hello everybody and welcome back. Today we're going to be discussing judicial review and why it's such a disaster. But of course first we want to understand what judicial review is. You're probably already familiar with the concept of judicial review even if you don't know the terminology. So judicial review is basically the power of the Supreme Court to declare laws unconstitutional, to strike them down saying that they do not conform with the requirements of the Constitution. What a lot of people don't understand about that power is it doesn't actually exist in the Constitution. That's right, judicial review doesn't exist in the Constitution at all. If you remember your civics class, you know that Article 3 of the Constitution is the one that actually explains how the courts will be set up and what powers they'll have. Now, Article 3 of the Constitution is actually very brief. You can read it in just a few minutes. And if you look at Article 3 up and down, you'll realize that there is nothing about judicial review. Article 3 basically just says we're going to have a Supreme Court, we're eventually going to need other courts, and that's it. It leaves the rest up to the government. So if the power of judicial review is nowhere in Article 3, if it doesn't exist in the Constitution, where did the courts get this power? I mean, this is the power that the vast majority of people actually think defines the Supreme Court, right? This is the Supreme Court's major check and balance against the other branches. So if this power isn't in the Constitution, where did it actually come from? Well, there was a case called Marbury versus Madison, and Marbury versus Madison is probably the most important Supreme Court case, if for no other reason that it establishes the power of judicial review and sets up the power and tone of the courts for the rest of the American experiment. So what happened in Marbury versus Madison to create judicial review? Basically, there was the election between John Adams and Thomas Jefferson. This election was very bitter, but Jefferson ended up winning. So when Jefferson came to power, he did not want to seat any of the judges that had already been appointed by Adams. There was a dispute as to whether or not those judges should be seated since they had already been declared judges by a sitting president. And so a lawsuit was filed by one of the judges, Marbury, who wanted to be seated. And when it was filed, there had been a law passed by the Congress that said that particular type of lawsuit could go directly to the Supreme Court. We know that the Supreme Court is an appeals court and mainly handles the rulings of lower courts. But at this time, the Congress had passed a law saying in this particular type of case, this writ of certiorari can be taken to the Supreme Court directly. Now, what the Supreme Court did is basically it listened to this case and it said, Marbury, we agree with you. You should be seated. You should become a judge. However, we don't actually have the power to make a ruling on this because the law that says you can take this directly to the Supreme Court, that says you can file this type of case directly with the Supreme Court, we're going to declare that law unconstitutional. It violates Article 3 of the Constitution. It's the legislative branch allowing people to skip steps in the judicial system that they're not allowed to skip. And so even though the court agreed with Marbury, they actually ended up ruling against him because they said, basically, we can't even hear this case. It's completely unconstitutional. Now, again, this is a power that does not exist at all in Article 3. And this is actually a brilliant stroke of power grabbing by the Supreme Court at the time. Because basically what they do is they say, we're going to say this is unconstitutional, which simultaneously looks like we are saying we can't do something. So it looks like we are actually refusing power. But in the long run, we're actually securing far more power for ourselves than we ever had in the Constitution. It was a very, very smart, tactically sound maneuver. They had the cover of refusing power while actually the whole time grabbing a vast new power that never existed in the Constitution, and thereby establishing themselves as far more powerful than they were ever intended to be. Now, you might be thinking to yourself, look, I listened in civics class and I know that this is a key component of checks and balances, and checks and balances are good. They're what divide the power of the government, and we know we all want divided power so that no one comes over and controls everything. No one branch of the government, no one person or set of people can actually consolidate power. So even though this judicial review was never actually first intended to be in the Constitution, even though it is a power grab, it's a power grab that ended up working out for the best because it created a more equal balance of the powers, and that's what we all want, isn't it? This is how judicial review existed for a very long time without actually being in the Constitution. We all just kind of agreed and went with it, and it's never actually been added to the Constitution. We've never had any kind of amendment that made it official. We've never done anything to actually consolidate that power and make it completely codified. We've just all kind of continued to go forward with it, even though it still to this day is not written down anywhere. So is judicial review a valuable check and balance? Maybe, maybe not. Let's look at it. So one thing people will say for judicial review is they'll say, even though the court has the ability to say something's constitutional or unconstitutional, the court itself can't actually write legislation or bring issues forward. And therefore, judicial review is not really that dangerous, because no matter what, the court can't actually create the situation in which it gets to declare something constitutional or unconstitutional. Someone else, like a president, has to take an action, or someone like a legislator has to write a law, and that law has to get passed and then enacted, and then it can be declared unconstitutional. There's a large number of things that have to happen before the courts can actually declare something constitutional or unconstitutional. And therefore, even though it's a bunch of unelected people who have a lifetime appointment to the bench, well, they can never actually write the legislation, so therefore their power is circumscribed, it's controlled, and therefore it serves as a valuable check and balance to the other branches. But is that really how that works? I mean, that's how we're taught it works, but is that functionally how it works? The answer is, of course, no, and we only have to look at one of the many examples in American history. For instance, you might notice that the Supreme Court makes rulings on things like abortion or gay marriage, and however you might feel about those particular social issues, if you look at the way in which they declared those things the law of the land, the way in which they made those things legal, it's a disaster area. If you look at any of the cases where that type of law is practiced, you know that basically the court looked into the past, looked into amendments that existed far in the past that were never intended to justify those two social advancements, we'll call them for now, and used past amendments that were never meant to justify those two decisions and said, nope, anything that goes against abortion or anything goes against gay marriage is actually violating those past amendments. And because it's violating those past amendments, any law that's still in existence is basically null and void, making that the law of the land. That's how gay marriage and abortion were legalized de facto across the nation. There was never a piece of legislation passed like it's supposed to be. There was never a constitutional amendment passed. It simply was declared by the courts. Well, where do they get that power? They get that power through judicial review. See, the problem is when something doesn't mean what it says it means, then basically it means whatever people want it to mean. And that's where we get into a lot of problem with the power of judicial review. When your rights or when prior amendments are up for debate, when they can change and form and move with the times, when we have a living constitution that is updated by the opinions of judges rather than by actual laws or amendments added or removed from that constitution, then that means that the people who are actually controlling the government are not the elected officials. They are not the people who are actually brought into power, in theory at least, by the people to represent them. The people actually controlling the government at the end of the day are the people sitting on the Supreme Court. They are the final word, and it doesn't actually matter what a law meant when it was written. It doesn't actually matter what an amendment meant when it was written. It only matters what the Supreme Court says it means at the time. Now, of course, this famously makes mistakes that progressives would acknowledge, things like Plessy versus Ferguson or Dred Scott, but it also creates ridiculous situations like the Second Amendment. Look, whatever you think about the Second Amendment or guns, the point is the intention of the Second Amendment is very clear. Individual Americans have a right to own firearms. And if you have any question as to whether that was the original intent, if you look at any kind of historical documentation around the people who helped form that particular amendment, it's very clear what they meant. Maybe you think that amendment's outdated. Maybe you think that that amendment was for a time when people had muskets. Maybe you think that amendment was for a time when people could have actually fought back against their government, but now the government has nukes, so there's no way that's ever going to happen. All those are completely reasonable opinions we can debate, but debating about the actual meaning of the Second Amendment is silly. The Second Amendment is very clear as to what it's there for. A bunch of people had just fought a government with guns, and they wanted the ability to do it again if necessary. Again, if you don't like that, that's fine. We can talk about why the Second Amendment needs to be repealed or needs to be modified, but pretending that's not what the Second Amendment means is dumb. Except that's what we've done in the United States for a very long time. In fact, the idea that personal firearm use is a guaranteed individual right is relatively new. Heller versus DC is the case in which the Supreme Court finally actually made that a clear interpretation of the law, but that hadn't been the case for over 100 years. And that's, again, a very clear constitutional right. If that amendment can be interpreted to mean whatever people want it to mean, then any of them can. And that's how judicial review destroys rights. Judicial review makes it the purview of the Supreme Court what rights we're actually going to pay attention to and which ones we aren't. As long as judicial review is in place, as long as Marbury versus Madison stands, the court has the power at any time to revisit any amendment, any law at any time and say, this no longer actually means what it says it means. It means something else now in the modern day. And that is very dangerous. We want a constitution that can be updated. We want a law system that can be updated. That makes sense. Time moves forward. People move forward. But we have that process. That process exists in the United States. But it's difficult, and people don't like to do it. It's much easier to control the Supreme Court at this point in American history, and so that's why each election now is framed as a battle over the Supreme Court. That's why people will elect, frankly, ridiculous humans like Donald Trump to the President of the United States, because at the end of the day, they realize the President doesn't have the power the Supreme Court does. And so this creates a very ridiculous situation where what is in theory a democracy is ultimately at the whim of a body of people who were never elected and never are up for re-election. They only either step down or die. That was clearly never the intent, but that's where we're at. And you can tell that this has a really adverse effect on civil rights. This has a really adverse effect on the rights that you think you have, the rights that we tell ourselves we all have, the freedom of speech, the freedom of assembly, the freedom of a religion. We tell ourselves that these rights exist in the Constitution, but if you want to know they don't, all you really have to do is look at our current situation with COVID-19, with the quarantine. How's your freedom of assembly going? Now you might say, hey, look, these things always have limits. Freedoms always have limits. Okay, but they don't have hard and fast limits, right? The limits are whatever the Supreme Court says they are, whenever they say they are. And of course, any law at some point is going to be open to interpretation. That is the nature of things. Laws are written down, but human situations are constantly fluid. They're constantly happening. And so there's always going to be some level of interpretation. But we are getting to ridiculous levels of interpretation, right? Quarantine laws almost never actually allow the government to lock down everyone. They allow you to lock down sick people, specifically proven sick people, but they don't allow you to lock down, I don't know, say 330 million people who may or may not at any time have the virus, and yet here we are abiding by laws that very clearly violate our ability to assemble. We also have governors and mayors who are specifically targeting religious communities. They are allowing people to grocery shop, they're allowing people to congregate for things like buying alcohol or buying all kinds of other supplies, but they're not allowed to go to religious services. Now look, it may not be wise to go to religious services. I'm a religious person, but I've been going to religious services online instead of in person since COVID started breaking out. But that doesn't mean that the government has the ability to physically stop you, to arrest you, to put you in jail, to fine you if you decide not to listen to them. If you actually had rights, if you actually had the constitutional right to assemble, if you actually had the constitutional right to practice your religion how you chose, then you would be able to go do those things even if the government didn't want you to. But of course, you don't. And if you think you do, go try it. See how it goes. Not well, I'll let you know. So what are the practical implications of this? Are we going to get rid of judicial review tomorrow? No. There's no chance that we're going to be removing judicial review from the Constitution anytime soon. So what do we need to understand about it? As people who are not part of the progressive movement, are not part of the cathedral, we need to understand the judicial system as a key aspect, a key tool of the cathedral. And because it has this ability to morph at any time, because the Supreme Court and the justices have the ability to basically go back and declare any law, any democratic act, any right invalid anytime they want to, we need to understand that this institution is a key lever in the power of the cathedral, because it constantly allows for things to be manipulated without democratic input, without any direct democratic vote. In fact, constitutional rights and restrictions actually become a bat that progressives can use to beat down their opposition. We actually see the rights and restrictions of the Constitution used to bind the hands of and control the opponents of the cathedral. So, for instance, when we talk about things like freedom of speech, when we talk about things like equal access to government resources, we'll see that progressives in the cathedral will use things like separation of church and state and the inability of the state to establish religion as a way to force religious conservative ideas away from public institutions. They use that as a cudgel to keep religious ideas out of universities, out of libraries, out of the education system, out of government. But they don't abide by that. They don't have to abide by that because they label their religion, they label their worldview, they label their tradition as non-religious. Because progressivism is technically not a religion, that means that it can continue to be propagated inside government institutions, it can continue to be spread by public institutions like universities, and so progressives can actually win a lot of battles by forcing conservatives to adhere to an interpretation of constitutional rights that they themselves never actually have to adhere to. Because at the end of the day, the progressives know that they have the cathedral, and they know they will never actually have to adhere to the same version of rights, the same version of restrictions of power that conservatives, right-wingers agree to. They don't have to play by the same rules. Because if at any time a individual right, a constitutional right, or restriction on power becomes inconvenient, the cathedral knows that they can simply redefine it. They can just move the goalpost, and that way they're always the ones in bounds. They're always the ones that are technically playing by the rules because they control the rules, and the rules shift the way they want them to at any time. And one of the key ways that the rules shift at any time is judicial review. I hope you guys enjoyed the Magic Arena. I hope this got you thinking about the concept of judicial review and how it gets used against right-wingers and conservatives in the United States, and I'll talk to you next time.